May it please the court. This case is about one primary issue. What does it mean for Congress to have created a strong preference in favor of mainstreaming in the Individuals with Disabilities Education Act for students receiving special education instruction and services? More specifically, this case is about the degree to which that strong preference in favor of mainstreaming requires a school district to mainstream a student who's been mainstreamed, who's been in the general education classroom, who has made progress in the general education classroom on the goals articulated in her individualized education program, who's received non-academic benefits, has made progress in that regard as well, whose behaviors have improved by the school district's own admission, but is lagging behind other students in the general education classroom in her academic achievement.
Can we go back to you said made progress? Isn't one big issue in this case whether she was actually regressing in the classroom and whether she needed some more remedial assistance in a different setting?
It's actually not an issue in this case whether she was regressing in the classroom. In fact, even the district court below indicates that she made progress both academically and non-academically. If you look, Your Honor, at Record on Appeal 307 and 310, the district court actually says specifically that the plaintiff had received academic benefits in the general education classroom, that the ARD committee in March 2020 undoubtedly recognized the plaintiff had received non-academic benefits in the general education classroom. The issue with that the district court below had was not that plaintiff had not received academic benefits in the general education classroom, and not that she hadn't received non-academic benefits in the general education classroom. It was really a question of what defines progress, what is meaningful progress. There's no question that she hadn't regressed. She had mastered 11 out of her 17 goals in her individualized education program. She had almost mastered 2 more out of the 17, and she was making progress on all the remaining 4, so there's no question of regression. But what the district court held, and this flies in the face of 30 years of this court's precedents from Daniel R.R. in 1989 to A.B. Versus Clear Creek ISD in 2019, the district court below held that progress is defined differently in the general education classroom. That, in fact, the district court in so holding disregarded the warning of this court in Daniel R.R. that it really doesn't matter what the progress of a child is with respect to the general education classroom in these circumstances. It doesn't matter whether she's making progress relative to her typically developing peers. What matters is she making progress with respect to her own goals, with respect to her own levels of achievement? The district court said, on the contrary, no, it does matter that in the general education classroom that progress is defined differently. Now, why did the district court say that? The district court ironically looked to the Supreme Court's opinion in 2017 in the Andrew F. case and said that changed matters, that because the Supreme Court in Andrew F. said that typically in a general education classroom, somebody who is fully integrated will typically be going through the general education curriculum in more or less lockstep with typically developing peers, that changes the analysis, and that in the end, if you want to be in the general education classroom, you have to be able to show that you're more or less going through the general education classroom at that same rate. But Andrew F. doesn't say that. In fact, Andrew F. says quite the opposite. Andrew F., in the Supreme Court's opinion, Andrew F. stands for the proposition that progress is measured pursuant to an individual child's unique characteristics, circumstances.
Well, let me ask you this. I'm still stuck at the point where you said, I think you said ROA 307, 310. I mean, essentially it was undisputed that she was progressing, but I thought the basis of the blended environment that was recommended was predicated on the school district and others noting lack of progress, not lack of progress across the board, everything, whatever, but generally either an insufficient amount of progress such that this blended plan was thought to be the least restrictive environment for her. And so at least, and I may have it wrong, we have to read it all, but I didn't think, I mean, this is after a long process during everything, but it was having reached the determination that a blended environment is what's needed, predicated on some progress, some not progress, not enough progress. At least that was my understanding. So maybe I'm wrong, and I don't want to take away from the rest of your argument, but I am stuck on that point.
Okay, and Your Honor, the difficulty is that the school district witnesses that testified to that point had the law wrong on this issue because they were measuring, they simply didn't understand the appropriate measure of what progress needs to be under the law. So the school district witnesses that testified, the special education coordinator for
Put
Comal.
aside for a minute what the law requires, and I get that because that's what we do, but I mean just within this educational milieu of, you know, IEP, et cetera, I mean, aren't they first basing it off of those criteria? I mean, I just can't, well, I just don't envision somebody pulling a law book off the shelf to figure this out. If these are people on the ground doing this against their own educational credentials, doing this with lots of kids, et cetera, and trying to make a determination. Now, later somebody's going to measure it against what the case law says, but I thought the blended assessment and all that was based on the educational criteria, et cetera, and the unique needs of this child. Am I incorrect? Or are you just saying that ultimate determination is antagonistic to what the cases say? Is that your argument?
No, the argument, Your Honor, is that the IEP was designed by the school district, and the IEP by definition under the statute is articulates the goals that are designed to meet the unique needs of the child with respect to the general education curriculum.
But test scores and advancement are relevant. It is not, they're not extraneous. I mean, we have a whole slew of cases, Leanne H. among them, that say that that while they are not the be-all, end-all, and the IEP is important, they're certainly to be factored in and included, whether you're making advancements.
Making advancements relative to the general education, typically developing peers? Yes.
Advancement and test scores are valid, important metrics that we should consider. Not
in which case?
that the district is allowed to consider, not just the IEP. Under you know, at least 3 or 4 cases I can think of under our circuit precedent. They're not the only thing, and you are right to steer us to the IEP and the fact that she is meeting a majority of her IEP goals. I would think that you're correct in your structure of this, but we can't just completely ignore these other things.
So, Your Honor, I believe the cases that you're referring to are, for example, DC versus Klein Independent School District, also Houston ISD versus Bobby R. These are cases that aren't really least restrictive environment cases, but they do, for example, a student who had a specific difficulty with reading comprehension in the DC case, a student with, I believe it was dyslexia in the Bobby R. case. This court did hold there that it is appropriate to look at testing scores, for example. But those are a little bit different because even those cases, in Bobby R., for example, even there, this court held that it's not so much whether the child does better in test scores relative to the rest of the class. It's not, even there, in those cases, it wasn't about whether that student was narrowing the gap between herself and the rest of the class. It was there absolute progress? Was there absolute progress in with respect to her abilities? There's no question that this child here was making absolute progress. And with respect to your question, Judge Stewart, the difficulty with the way that the school district witnesses were addressing these issues, they all recognized that she was making progress on her IEP goals. That's right there in our document, March 2020, the very document that they used to suggest that she ought to be placed elsewhere. Right there it says she was making progress in the IEP goals. The problem is that some of these school district witnesses either said, well, she's making progress in her IEP goals, but the gap between her and the rest of the typically developing peers is widening, and we think that's a problem. One of the school district witnesses, the general education teacher on whom the district court below placed a great deal of reliance, didn't even know what her IEP goals were. That's right in the record. She didn't know what the IEP goals were. All she knew is that she wasn't keeping up with her typically developing peers. And because of that, the general education teacher said, I don't think she should have even been in second grade, much less be in the general education classroom, much less advancing on to the regular education classroom.
How do you reconcile what you call absolute progress with her IEP goals? How do you reconcile that with the fact that she had declining test scores, that she had failing grades? I don't understand how you can ignore that.
Because the failing grades, when you look at for example, the teacher for whom I just made reference, the general education teacher, she was testing plaintiff, not according to her IEP goals, which she didn't even know what they were, but she was testing the student based on the full general education curriculum, and she was failing because she was being measured directly against her typically developing peers.
But not age, it wasn't age appropriate. She wasn't put in with, she was much older than the general population of her class. Like this has been going on for what, 5 years?
She was.
What is she doing now? Is she still in this same class she was in before?
Right now, as we sit here today?
Yeah.
Yes, because we invoked stay put under 20 U.S.C. 1415J. So she's still there. She's, my knowledge, and of course none of this is in the record, but to my informal understanding, she's doing fine. But in terms of...
Well, you thought she was doing fine before. So I can't really evaluate what you're saying.
Well, right, but under the IDEA, doing fine, and based on all this court's precedents, doing fine is predicated on the IEP. It's what is the IEP? The IEP, by definition, is an individualized education program includes a statement of measurable annual goals, including academic and functional goals, designed to meet the child's needs that result from the child's disability, to enable the child to be involved in and make progress in the general education curriculum, and meet each of the child's other educational needs that result from the child's disability. If she's mastering the goals under her IEP, if she's advancing based on the definition and statute as to how progress ought to be measured, then she should be in the general education classroom. The district court did not deny that she was making that level of progress. The hearing officer didn't deny it. The school district witnesses didn't deny it. They all simply said that it's not good enough because she's not making progress relative to her typically developing.
Let me ask you this. You seem to be traversing, among other things, the quality of the evidence that's in the record, those who testified, et cetera. So there's a multi-day hearing, et cetera. So the first question is, when we get into this record, the teachers, those who testified, who you said, didn't come to the curriculum, was there contrary evidence in there? And the argument is that the hearing officer, believed the wrong people, or there was mixed, or is there just one flow of evidence? And your view is that that's, not appropriately interpreted. Do you understand my question?
I do exactly understand your question, and it's the latter. It's not that this isn't really clear error review where we think there's...
So do you want us, in effect, to do de novo review of this record, read every shred in here, and conclude that, notwithstanding those below who read it, the end result is something different? Is that what you're asking us to do? Not literally, but I mean, is that what it would take for us to read all the testimony, et cetera, and somehow conclude that others who looked at it came out the wrong end? Do you understand what I'm saying?
I don't think it would require anything so onerous. I think that all this court would have to do is read the district court's opinion and read the hearing officer below, because the hearing officer below, for example, at ROA 357, she says the same things that I'm saying in terms of...
All right, so then you're saying the district court, Judge Pullum's opinion, is at variance with what the hearing officer determined. Is that what you're saying?
I'm not. What I'm saying is that the hearing officer and the district court below all found, as an evidentiary matter, that plaintiff was making progress on her IEP goals, that she was making progress with respect to non-academic benefits, that her behaviors were decreased. All of those things are undisputed in the record.
Well, see, you keep saying what's undisputed, and I keep getting to the point, I've been around a while, I'm figuring the two of y'all wouldn't be here if there was all this undisputed stuff. Now, maybe I'm getting it wrong, but it seems to me there's some dispute that's the miss. So that's all I said. Let me ask you this. Tell me in a declarative statement what relief from this panel would look like for your client. You follow my question?
I do follow your question, Your Honor, and because the district court understood the facts but misinterpreted the law, I think that under Whole Women's Health versus Paxton, that it is appropriate to reverse on that basis, reverse and render on that basis, that the district court understood what the facts were.
All right, so your argument to us, we're looking at legal error. Legal error. Because you said it's not a clear error. You said it's not a clear error review. So your argument to us, our holding for you to prevail, is that there's legal error that infects the factual determinations below, therefore vacate, right?
That's exactly right, Your Honor.
All right, I got you. You got a red light. You've reserved your rebuttal time, but I think I know what your position is, at least at this point. All right, so let's hear counsel opposite tell us about the undisputed matters that you smiled as I said.
Thank you, Judge Stewart. May it please the court. My name is Andrew Tatgenhorst, and I represent the appellee, the Comal Independent School District. This court should affirm the well-reasoned decision of the district court below, rendering judgment in favor of the district's proposed placement for HW. The district court committed no clear error in finding that the district complied with the IDEA by proposing a legally compliant program that provides the student with a free, appropriate public education in the student's least restrictive environment.
Opposing counsel seems to be of the position that as long as you're progressing on your IEP, you can't take the child out of the mainstream classroom, for lack of a better word, because the sine qua non of it is whether or not you're progressing under your IEP, and that's the law, and that the district court was wrong in looking at other factors. Can you help us? Is that the law, and was the district court wrong at looking at other factors?
No, I don't believe the district court to be wrong in following the Daniel R.R. analysis by evaluating the benefit that the student receives from the general education setting. In part, that includes, yes, progress on IEP goals.
Is it just one thing, or is it the thing? Progress on the IEP goals, is that the one factor that is dispositive, or is the district court allowed to look at other factors? And what case says that?
I believe the Daniel R.R. case says exactly that you can look at these factors and look at the benefit the child receives from the general education setting, and that's not narrowly tailored to the IEP goals. The IEP goals are simply a subset of targeted skills that the district wants to ensure that the student achieves on, right? And so that's certainly an important metric when we're evaluating progress, but it's not the only metric.
Does the district court dispute that she had achieved 11 of her 17 IEP goals?
So
I mean, not the district court, just the district. Do you dispute that she had achieved 11 of her 17 IEP goals?
There is some progress there, right? And there is some actual meeting of progress. The problem is the sort of stagnant progress that we've seen and the inconsistent progress. And the record is...
So are you saying you do dispute that she did 11 of 17, or you don't dispute it?
We don't dispute that, but there is some context with that progress data, right?
Do you dispute that she was progressing in her social goals, that in her social development, and didn't act out, that she was, better behaved, for lack of a more proper term?
We dispute that, yes, ma'am. That the benefit that she got from the general education setting was not necessarily clear from the record. The district court below found as much, saying that it's unclear that she received any benefit from the general education setting and that any socialization was not beneficial to her in that setting.
So what is the legally correct thing that you would ask us to hold today?
I'd go through the Daniel R.R. analysis, look at the benefit that she was receiving in the general education setting. That's to include progress on IEP goals, even though the district asserts that progress was inconsistent and that those goals had just recently been lowered. I would look at the benefit she receives from the general education setting in terms of whether she can access the curriculum. What does her education in that setting look like? Can she achieve some benefit, whether it's from accessing the curriculum, modeling her peers, interacting with her peers, progress on IEP goals, and so forth, and then balancing that as Daniel R.R. requires.
Are you saying the court should do that, or are you saying we should uphold the school district's analysis?
Yes, ma'am. I'm asking that this court uphold both the decision of threefold, the decision of the educators in developing an IEP, the decision of the hearing officer in finding that IEP legally compliant and LRE, and the district court in finding that proposed program was the LRE and is proposed to deliver a FAPE to that student.
Well, you heard Counsel Opposite's arguments about, I guess, the testimony of the teachers, et cetera, et cetera. So, one, what's your take on that? And then number two, clearly reading this, this has gone on for a while, we get it, but I guess axiomatically in these kinds of cases, sometimes they do go on for a period. So should I conclude the district just got fatigued with this and said, King's X, not literally, but, we've reached this point in the continuum and we're here, and so it's time to, move on, so to speak. I don't mean that in a caustic, uncaring sense, but if there's some timeline, we've moved here, we're here, so we make a decision to do something else, as opposed to, some cases take longer than others, and if she's making 11 out of 18, then, we continue doing it. If it takes longer, it takes longer. Do you understand what I'm saying?
Sure, and there's no rigid framework for that, right? The IDEA, the first I, individualized, right? The Individuals with Disabilities Education Act, and this court's precedent is very clear that it must be individualized, and so there's no clear framework for that. But yes, Your Honor, there was some attempt. She started off in the general education setting, and the district does increase its level of support over time. As we see lack of progress or stagnant and consistent progress, the special education instructions, the supplementary aids and services in that setting are increased. And that's what the district's proposed here, right? It's a blended placement. It's not an all or nothing approach. The approach here is to simply add more special education time than she currently has to address her ongoing and increasing needs. With respect to that stagnant...
Where in the blended approach is the rub for the other side?
I think it's in the amount, Your Honor. I can't answer, what exactly the disagreement is in terms of, what amount would satisfy the appellant. But it is a rather stark increase in special education time, but that's because of the demonstrated need the district believes to be present. With respect to the data showing inconsistent performance or lack of overall progress, I can point the court to the record on appeal at 981 through 990, 2191 through 2198, and 2208 through 15. With respect to the overall progress in the classroom, I think it's important to understand how this all fits together, right? This court's clear standard under Michael F., we analyze 4 factors to determine whether or not a student is receiving FAPE, and the least restrictive environment mandate is one of those important factors, right? And Andrew F., the Supreme Court's decision that articulated a FAPE standard, did not alter that Michael F. standard. Those factors are still in play under this circuit, and that this court's decision in ER versus Spring Branch is clear to that point. So Andrew F. does not shift anything in terms of the district standard under this court's precedent. However, when you look at the LRE mandate, sure, there's a clear preference for the general education setting, but that preference can be overcome, and that's the whole thrust of the Daniel RR analysis. You use the Daniel RR analysis to determine whether or not that preference, that important preference for the general education setting, can be overcome for a particular student. One thing I think is important to note, too, is that districts aren't required to require children to fail before moving to another placement, right? It's inconsistent with the aims of the IDEA to simply wait for a student to fail in a particular setting and then move them to a more restrictive placement. The district, as here, is supposed to monitor progress, track the student's progress and the benefit they're getting from each setting, and make a blended placement or a placement recommendation generally that offers the student a free, appropriate public education. And so waiting for the child to fail would be antithetical to the aims of the IDEA for numerous reasons, one of which, of course, is that we'd have failing students before we could do anything about it. And second, that doesn't benefit the district's legal position, because waiting for a student to fail would put them in a tenuous legal position in terms of, if we waited for a student to fail, we would be fighting a FAPE argument saying that we had denied FAPE to the particular student before moving on.
How old is this student now?
Trying to do the math in my head, 9, I believe. I may be incorrect on that, I'm sorry.
And what's the age of the students in the regular class?
It's higher, Your Honor. I don't know for sure, though.
So how long does a child go to this elementary school?
Through 5th grade, and it would depend on...
11.
It would depend on, correct, and it would depend on various circumstances, right? They wouldn't necessarily go to that specific school. School districts can serve students with disabilities at various settings, but as a reference point, yes, ma'am. The key factor in the LRE, in applying the LRE analysis, is the appropriate progress, and that's that Michael F. factor, and that's what Andrew F. in this court's precedent and Michael F. demand of public schools. We can't simply offer some benefit to public school students. And surely that there is some benefit to be offered for really any public school setting, right? But that's not the important thrust. It has to be that meaningful benefit and appropriate progress that must be demonstrated in a particular setting. Simply permitting any benefit, like I said, if we lowered the standard to just allow for any benefit from a classroom, there would be certainly lower the threshold for school districts meeting the needs of students with disabilities. In this case, the district court and the hearing officer found that the student was not making that sufficient progress in that setting and was not getting a meaningful benefit from the regular education setting. She had a constant need for attention, consistent prompts, redirection, and reinforcement, and her limited engagement with peers in the regular education classroom underscored that need for a more restrictive placement. She was failing to achieve passing marks while also not mastering some of her IEP goals, and the district court cites to no specific benefit derived from peer modeling, although that's sort of assumed into the built-in preference for the IDEA. However, the court recognized that that's a potential benefit and said that that does not cast in favor of HW here. Much like the student in Daniel RR itself, where the court in Daniel RR found this factor cuts in favor of keeping the student in the general education classroom, but that sufficient evidence was there to move the student to a more restrictive placement. Of course, the behaviors that are clear in the record are another reason and speak to that fourth factor, that removal is appropriate under IDEA because of the distractions and sort of the burden in the classroom itself.
Elaborate on that a little bit more. Counsel opposite, I think in his brief says the court or the district didn't rely on, disruptive behavior as a factor here for the decision made. What does the record show?
So the record will show numerous acts of sort of aggressive behavior that are sort of assumed to be disruptive, right? I don't think you find the district court saying these are exactly disruptive behaviors and that there's evidence of an impact of these disruptions. But the district court does point out that these are disruptive behaviors, right? And those include hitting or biting a classmate, taking things from other students, and at least one incident where she wiped the materials off the desk of a student next to her. And so the district court says there's no evidence to show that there's actual disruption, there's no testimony of students that say this disrupted me in the classroom, but it's assumed that those are disruptive behaviors that obviously interact or obviously impact the classroom. And with all four of those factors properly weighing in favor of the district court found that the district's attempts to implement the program in the regular education setting were unsatisfactory, and it could not do so. Comal ISD asserts that the district, that the HW has failed to meet her burden with respect to all the Daniel RR factors, and has failed to demonstrate that the three previous fact finders made an error in the review of this case. Our friends on the other side make much ado about the AB case, and I want to just touch on that for a brief moment. First, I think it's important in all IDEA cases to understand, again, coming back to that that individuals, these are all individualized determinations. The students go before an ARD committee, and we talk for hours on end, and there's many people involved in the process of deliberating about what's an appropriate IEP for a student. And so that changes case to case, student to student, and it's critical that these plans be individualized. And so I think it's difficult to compare one student's placement versus another. And so when we look at case law, we can gain valuable tests and insights, but it's difficult to compare the exact needs of one student versus the needs of another student, and including what a student needs in terms of an educational environment. That said, I can't overstate the clear difference between this case and AB, both in the underlying facts and the procedural posture. First, in AB, the hearing officer in the district court found that the special education setting was not the student's LRE, and that's not the case here. Both previous fact finders found this was the student's LRE, and I think it would be an extraordinary step for this court to overcome the fact finder at both the hearing officer level and the district court level and find something completely different. Also, in AB, the hearing officer found the district that the proposed educational setting was not the student's LRE. And again, the exact opposite is true here. Also, in AB, there was direct benefit that was found to be attributed to the general education setting. And so when you look at the fact findings in that case, you'll find that the court said, look, there is some benefit that's actually being derived from this placement in this setting. And that's not the case here. We've got no finding to that effect. Of course, it's assumed in the LRE mandate, right, that there's a preference for the least restrictive environment for the general education setting, but again, that can be overcome.
I think they cited a Sixth Circuit case also, I think. I think Counsel the opposite, they cite a Sixth Circuit case that went the other way, that used just, can you just elaborate on it?
Sure. The LH case out of the Sixth Circuit, yes, Your Honor. First of all, that case, obviously different circuit and a different test. They're not applying the Daniel RR analysis.
Is our test out of sync? I mean, Judge Batchelder's a very distinguished judge. Is our test out of sync?
No, ma'am. They simply adopted the ranker standard under that court's precedent, and it's just a separate test. I haven't done too much analysis between the differences in the test. I know it to be a different test that calls for different things. Frankly, I believe the Daniel RR test is more involved, and I say that because of the level of factors. There's a lot more of them, and I presume that that's a good thing. But aside from that, I haven't done a...
And I don't mean to deter you from the main question that you've been asked. my colleague asked you a main
Sure.
question.
So the LH case, again, it's difficult to go back and forth because that's a completely different standard. But the argument being made there was a little bit different than the argument being made here. The argument made there was basically trying to write out the mainstreaming preference, to say that, well, the student goes into the general education classroom and they're basically a class within a class. And so they are educated completely separately. They achieve no benefit from being in this class. And they're basically in their own separate classroom. And the court said, no, that's approaching it that way would write out the LRE mandate out of the law. And I think that's the right approach. We can't simply say that just because the student, learns on a modified curriculum that they would achieve no benefit from being in the general education setting. The difference here, though, is we need some benefit to be proven. We need to show some actual benefit is being garnered from the educational environment in the general ed setting, and that's simply not the case. I want to touch, too, on the district's obligation to provide a free, appropriate public education. Again, the LRE mandate is one of the critical factors under Michael F. and should be reviewed, but it's also important to remember that the district's obligation under Michael F. and under Andrew F., the Supreme Court standard, is to ensure that a free, appropriate public education is being provided. And in those standards, you'll find the need under Andrew F., it's put as appropriate progress in light of the child's circumstances. Under Michael F., it's an individualized program that confers meaningful academic and non-academic benefits. And so the district needs to be sure to meet those demands of the IDEA while also meeting the demands of the LRE and ensuring that if the student's needs overcome that LRE mandate, that the student can be removed to a placement that's more appropriate for that student. In sum, I would ask that this court, again, affirm the well-reasoned decision of the district court, and Comal ISD asserts that there is insufficient justification for overturning the educational decisions of school officials, the findings of the hearing officer, and the findings of the district court. Nothing that's presented in this now third round of appeals justifies the extraordinary action of overturning both finders of fact and crafting a new LRE test. And so we'd ask that you affirm the district court's decision. Thank you for your time.
All right, thank you, sir. All right, back to you, Mr. Whitman, for rebuttal.
Thank you. My colleague, Mr. Tatgenhorst, indicated that the school district disputes whether plaintiffs' behaviors were increasing, but I'd like to direct the attention of the court to Record on Appeal 2813. The district's own behavioral specialist testified that by the time of the decision to place plaintiff in a more restrictive environment, plaintiff had adopted new alternative behaviors that are more socially appropriate and had increased her functional communications. Their own people are testifying that. It's really not disputed in the record. Certainly, there's evidence in the record that occasionally she would do something maybe once a day, her speech therapist said. But there's no evidence at all that this was disruptive to others in the classroom. In terms of my colleague's effort to distinguish the AB case, the first point that he made was, well, the hearing officer in the district court in that case found differently, found that that AB had been achieving meaningful benefits in the classroom. But here, the hearing officer and the district court found the same thing. They just didn't consider that that was sufficient here because of misapplication of the law. To simply rubber stamp that without an examination of whether the legal predicates were appropriate is not appropriate here. That's not an appropriate mechanism for distinguishing AB. The other point that my colleague made about distinguishing AB was that there, the district court found that the child had received benefits from the general education classroom. But here, and I mentioned these record sites before, that the district court here explicitly recognized at 307 and 310 that plaintiff had received academic benefits and non-academic benefits in the general education classroom. And I'll point the court to another site from the district court's opinion. This occurs at 317, where the district court recognized that plaintiff no doubt may benefit from the language models of her peers in the regular education setting or in other ways. This was a point that was explicitly made in Daniel Aurora. This is something that makes it appropriate for a child to be in a regular education classroom is if she can benefit from language models and socialization models. The district court here recognized that that was true here, just as the district court recognized that in AB. There are really two sets of cases from this court that are sort of meaningful, especially meaningful in this context, I think. One is AB, because in AB you have a very, very similar facts where the child has behavioral issues that are improving, the child is in general education but not at the same level as his typically developing peers. There he was in third grade, the work was modified to about kindergarten level. Here she's in second grade and the work is modified to about kindergarten level. There this court decided that it was appropriate, even though AB was nowhere close to being on level with his typically developing peers, it was appropriate for him to stay in the general education classroom. There are really two other cases that have somewhat similar facts where this court went the other way, and that's Brillen versus Klein Independent School District and the JH versus Fort Bend Independent School District. Those cases were along the lines of what my colleague was talking about here, where you don't want to wait for the child to fail. Because there what had happened was that the child had gotten to a certain level with respect to the general education curriculum that they literally, in both cases, they literally stalled out. They were making no progress on IEP goals. They had literally started to refuse to work. Their behaviors were increasing. And so the court basically decided that here, the general education classroom is actually hurting these children because their behaviors are increasing, it's blocking their learning, they are unable to move forward, so they need something different. That was completely the opposite in AB. Certainly at the beginning of his third grade year, he had difficulties along those lines, but the school district figured it out. Here, exactly the same thing. Plaintiff is moving forward on her IEP goals, her behaviors are decreasing. Despite her presence in the general education classroom, she's receiving academic, non-academic benefits. She should be in the general education classroom, and every precedent from this court says as much. Thank you very much.
Did you tell us how old is she now? How old is she now?
How old is she? She was 9 at the time of the due process hearing, so she would be, that was in 20, yes, sorry. It's in 10 today. But she was 9 at the time of the hearing at issue.
Okay, thank you.
Thank you.
All right, thank you, Mr. Whitburn, and thank you both counsel for your briefing and argument in it. We will review the record closely in all the cases that you've cited, and we'll give it our best shot to resolve the issues. Thank you. That concludes the arguments in this case.